Thank you, Mr. Speaker. The bill before us proposes 3 changes to the rules of royal succession for the New Zealand monarchy. This emerges from a political agreement at head of government level at the Commonwealth Heads of Government meeting 2 years ago. First, it would abolish primogeniture, the precedence of younger brothers over elder sisters, thereby ensuring that succession is not dependent on a person's gender. Second, it would allow individuals within the royal line of succession to marry a Roman Catholic. And third, it would restrict the requirement of royal consent for marriage to just the first 6 individuals in line to the throne. The bill raises issues of a deep constitutional nature, and these are, of course, placed in an historical context. There's often a tendency to justify any shortcomings in universal human rights in the context of historical anomalies. There was a case not so long ago where the UK Supreme Court argued in asserting that particular electoral laws pertaining to a particular bailiwick were consistent with the European Convention on Human Rights, with the quote that laws, even anomalous laws, have to be considered in the round in light of historical and political factors relevant to a particular place. While if one were starting from scratch, there could be few who would think that the law might be unsatisfactory, it did not follow that human rights would be breached. So you have issues that are not simple and inevitably will occasion a penetrating discussion, not only in this House but in the wider society. People can hold strong views on these issues. There are various points to consider, both constitutional and political. First, the right of primogeniture. There can be no opposition, surely, to abolishing the right of primogeniture. The only point to note is one of astonishment that it has taken so long to bring the British and Commonwealth law up to speed with universal human rights that reflect the Western values that we all delight in trumpeting. It was Scott Simpson, just a moment ago, who spoke about an elite group of nations moving to legislate with great respect. That's absolute rubbish. Our 16 jurisdictions are a group of nations. We are not an elite group of nations. There is no such thing as an elite group of nations within the universal context of human rights. And he also was animated enough to say that we were bringing our law on this matter up to speed with universal human rights. Not totally correct. We're inching along in that respect to bringing them up to speed with universal human rights, but we're stopping short of it. The second issue is the freedom of royal marriage. Allowing the British and Commonwealth monarch to marry a Roman Catholic is fine and indeed is necessary. But as I understand it, while the Act of Settlement states that a monarch may not marry a Roman Catholic, it also states that the monarch, quote, shall join in communion with the Church of England. That is, the monarch must be an Anglican and must perform the duty of defender of the faith, at least in England and Wales, though not in Scotland or Northern Ireland. So the exclusion applies to all other faiths, including any declaration of non-faith. As such, it is an infringement of the UN Civil and Political Rights Covenant, which would accord the right of any human to have freedom of religion and occupy any position notwithstanding. The Crown Law's view is that the bill is consistent with the Bill of Rights because, quote, the rules governing succession in a shared hereditary monarchy are historically and politically complex and inapt for detailed Bora scrutiny, end of quote. This seems, with respect, to be a weak argument. The current succession laws of the British monarchy, including these proposed reforms, undeniably infringe upon universal human rights, even in the context of this draft bill. There is a strong argument for republicanism, although let me emphasise that republicanism is not Green Party policy. Now, the third change, restricting the requirement of royal consent. Seeking consent from the monarch by the first 6 in line to the throne is also such an infringement. It is a minor point in terms of New Zealand domestic debate, but it might be queried whether the New Zealand legislation will or will not apply to the Cook Islands and Niue and even the Ross Dependency. Presumably the British legislation will, quote, directly pass through the New Zealand Governor-General acting in right in a different capacity in those jurisdictions. We would be interested to get an opinion from the government on this point. The shared monarchy makes it required that all 15 realms outside the United Kingdom pass identical legislation. Agreement to that effect was given, including by New Zealand, at the Commonwealth Heads of Government meeting in 2011. This requirement for collective legislation by 16 jurisdictions effectively circumscribes New Zealand's freedom of constitutionality, another argument for republicanism. These constitutional considerations effectively rest on a set of broader considerations. This is probably another case of the New Zealand public needing to judge whether a reform goes far enough. There will be those who think it does, and those who think it does not. For its part, the Green Party regards the draft legislation as being useful insofar as it rectifies some serious shortcomings in the New Zealand constitutional system. But we also regard the bill as not going as far with the reforms as it should. Insofar as the current New Zealand constitutional system precludes a Roman Catholic from being head of state, or a Hindu, or a Muslim, then it breaches the Universal Declaration of Human Rights. Whether that applies to the Governor-General representing the head of state is another issue. It may have been the case that previous Governor-Generals have converted to Roman Catholicism, and that would be an interesting point of fact. Does the bill go sufficiently far with reform as to warrant our support? Our answer is no, yet we do not wish to oppose the bill since it does effect some positive change. The Green Party will therefore abstain on the bill. If it were a normal piece of domestic legislation, we would work to strengthen its provisions and advance some amendments in the Committee of the Whole. But this is not a normal bill. It is a piece of the Constitution that addresses the monarchy, and that monarchy is shared across 16 sovereign jurisdictions. As such, the rules have to be identical. You could not have rules for New Zealand choosing a shared monarch and different rules for Britain or Australia. Our rules, no doubt, would be regarded as null and void to the extent that they differed from those of the UK. It is a supreme irony that 16 so-called sovereign nation states are unable to make their separate sovereign determination of the rules choosing their own head of state. I note the intriguing judgment in a Canadian case that, quote, one cannot accept the monarch but reject the legitimacy or legality of the rules by which this monarch is selected. True up to a point, but this bill before us is altering the rules and thereby rejecting or casting out the previous rules. So the matter is relative, though not so relative as to enable freedom of legislation over one's own head of state. The Minister said just a moment ago that the rules have to be consistent across the realms, and a bill is proceeding through the UK Parliament, but that this does not, of course, work for us. We must do our own legislation. So be it. We shall abstain on the bill while making it clear, as appropriate, what our views are on certain of its aspects. Thanks.
Order. Order. I'm calling Simon O'Connor.
Mr. Speaker, I didn't think I'd be quoting Voltaire, but for